welcome to Zoom with Czarny. I'm Dustin Czarny, Democratic Elections Commissioner for Onondaga County, and welcome to my interview show. Today I have Steve Williams. He's a former congressional candidate and partner in Smith Sovak law firm, and also a former federal prosecutor and JAG officer. He's somebody who I felt would be a great resource for us to talk about the Trump convictions that happened last week, the 34 convictions against former President Trump for falsifying business records, among other things. I hope you stay tuned for that conversation. It was a great conversation. This week, we're getting ready for the start of early voting, which happens next week for the June primaries, as well as the June 18th. So we have the June 25th primaries and the June 18th village elections in the village of Liverpool. I did a great commissioner in a car about that earlier this week about all the deadlines. Check that out if you're interested in voting for either of those. You can go to onvote.net and get an absentee ballot, or you can go to early voting or election day voting for both of those elections when they're happening. So check that out. This is also the wrap up of the legislative session in Albany. We'll find out if any of the election related bills that I've talked about in previous podcasts get passed. Most of them have been passed by the Senate, but it seems to be the Assembly is the holdup right now. But there's always a lot of bills passed in the last couple of days, so we'll see if any of those are on there. And that's it. So stay tuned for my interview with Steve Williams. He is a former federal prosecutor, partner in Smith Sovak, all around great knowledge about the legal process here in New York and on the federal bench. And I hope you find it as informing as I did talking to him. All right, enjoy. And we're back, and I'm very happy to have my good friend Steve Williams. Steve Williams is a former congressional candidate and someone who has represented me, in my role as elections commissioner, and he's a great area attorney. I thought it would be great to have him on to talk about the Trump convictions that happened this last week. Steve, thanks for coming on Zoom with Czarny.
Very happy to be here, Dustin. Thanks for having me.
So, Steve, before we get into the big event, let's talk about you. Why don't you introduce yourself to the viewers, listeners, and tell them a little bit about your background?
Sure. I'm an attorney here in Syracuse with the Smith Sovak law firm. Been here, oh my gosh, a long time, decades. Before that, I was a prosecutor. I was a federal prosecutor, and I was also an attorney in the Navy. I was a lieutenant commander in the United States Navy. So I have a lot of experience in both federal court and state courts all over the country, frankly. I've tried cases in Texas and New Jersey and New York and California, just about everywhere.
Yeah, and that's exactly why I wanted to have you on, because I knew you had the background knowledge and as a private attorney, the ability to speak on this pretty freely. And I think that's where I'd like to start. Obviously, the case happened. It was a lot of people describe it as a novel theory of the falsifying of business records and upgrading it to a felony, because it was in the in the committing of another crime, and the other crime was the campaign finance violations, the federal campaign finance statutes. So I guess I'd like to first get your impressions of the case overall. Was it a strong case? I mean, obviously it resulted in conviction, and we'll talk about that as well. But what do you think about the case that Alvin Bragg and his office in Manhattan brought against the former president?
Well, I thought Alvin Bragg did a great job with what he had. The crime here is not the crime of the century. I think most folks understand that. Typically, these falsifying business record charges are misdemeanors. Somebody will get a slap on the wrist. This was bumped up to a felony because, as you pointed out, they charged him with having falsified these records in furtherance of another crime. and that made these a felony. And it's still, once again, not the crime of the century. The underlying crimes were violations of the Federal Election Campaign Act, finance election law. So these aren't huge crimes, but they are crimes nonetheless, and they are felonies. And the prosecutor did a great job putting on just enough evidence and not overtrying his case, and he got the conviction.
So, you know, we talked about the prosecutor here, but what about the defense of this? You know, I mean, I know the defense attorneys probably are dealing with obviously now a guilty client, but it's really hard to defend when you deal with somebody who seems to have been, excuse me, more worried about the political outcome of the case than the actual legal outcome here. But what did you think of the defense and the defense they put on in this case?
Well, from what I saw of it, I wasn't overly impressed. And I'm trying to be objective. I think the lawyers are good lawyers, but I wasn't overly impressed. And I say that for two reasons. Number one, the attorneys representing the former president were somewhat restricted because, you know, they're confined by the facts of the case, right? They can't make up facts. Like, the facts are the facts. And secondly, I think they should have focused a little bit more on intent. And what do I mean by that? Okay, so they denied that Trump falsified his business records. Okay, but I think they should have said to the jury, assuming President Trump did that, you need to focus on why he did it. And we respectfully submit to you that he did it not because of the presidential campaign, but because he didn't want his wife finding out about this. And if you find that he did all this because he didn't want his wife to find out about this time he had with Stormy Daniels, then he's not guilty of a felony. And they didn't walk that fine line. And I think they could have, because I think they could have created reasonable doubt on that issue. In other words, was he burying this story really because he wanted to keep secret some kind of political contribution? Or was he burying this story because he didn't want his wife to have to read about it in the paper? And if the jury had any doubt about that, they would have found him not guilty.
Yeah, I mean, it does seem like they got hung up on the denying of the underlying incident of the affair with Stormy Daniels and not actually defending the actual crime that was being and I'm a layperson, so you know, you know more about this than I do, and that's why I have you on. Were you surprised at how quickly the jury came back here? I mean, with 34 different counts, a lot of people thought that the jury might be out for a while. They were only out for 2 days. And in fact, it seemed like on, you know, Thursday night when the conviction came that the judge was going to send them home. And then all of a sudden he got a note saying that that they have a verdict, and you know, at 4:30 at night, you know, and so they didn't even go into Friday. And I think a lot of people thought they were going to go at least a week or two of deliberations because of all the counts. Were you surprised at how quickly they came back and that there was all 34 counts were there?
I wasn't surprised at all. I thought that the evidence was straightforward. The defense put on very little in the way of evidence. I think they called one witness. The case is not that complicated. You don't have to pour over thousands and thousands of documents. They either believed the witnesses that the prosecution presented or they didn't. It was quite simple. So I wasn't surprised. And in fact, I was actually getting to a point where just with 2 days, I was wondering, is there a problem here? In other words, is the jury going to be hung, or are they going to come back not guilty? Because, you know, the longer they deliberate, there's the greater likelihood of a hung jury. And for example, you know, when the jurors were being chosen, they had to tell about themselves. And I know, for example, juror number 2, he gets his news solely from President Trump's Twitter account. I forgot what it's called. Forgive me.
Truth Social.
Thank you. Truth Social. That's where he gets his news, right? We knew where all these jurors got their news, and they got them from all different sources. He said, I get it only from Truth Social, period. So, you know, he could have been a holdout, right? And I think that the Trump team felt that they were progressing towards a hung jury. And in fact, they were all kind of happy in the courtroom on that last day at 4:15, thinking they're going to be sent home. It's another day without a verdict, and we're getting closer and closer to a hung jury. So I'm not surprised. I thought they would have come back quickly, even sooner than they did.
Oh, okay. Well, so now we have, right? We have the 34 counts of guilty. And before we get into the avenues that Trump has to appeal, or if he can appeal and how long that's going to take, the judge did set sentencing for July 11th. So what is that, like about 5 weeks away? What happens now? Because I heard a couple podcasts, read a couple articles about, everybody thinks of, you get sentenced, you go right to jail, whatever. I mean, but that's not really what's happening here. We got 5 weeks in between sentence or the verdict and sentencing. What goes on now in a convicted felon? What are they supposed to do in these next 5 weeks?
Right. Well, what happens is the judge collects information. And he collects information from both the prosecution about the convicted felon, and he gathers information from the defense and other sources. And he's going to use all that information to try to render a just and fair sentence. And it takes time to compile that information. That's why we didn't go right to sentencing the very next day. And that's where we are. The judge he's gathering information. He's going to sentence President Trump on the 11th. But if he is sentenced to jail time, and I will tell you, I doubt that's going to happen. I really do. These, once again, it's low-level felonies. He's never been convicted of a crime before. He's 78 years old. I'd be a little surprised if he got jail time. But even if he were to get jail time, it would be suspended pending the appeal in all likelihood. So nobody's walking out of that courtroom and going to jail on July 11th.
I tend to agree with you that I don't believe I never really believed he was going to get sentenced jail time, even if it was, because I think there's a practical issue here. I mean, if it's jail time, it's in Rikers. If it's in Rikers, are the Secret Service hanging out in Rikers with, a former president, sitting there? What is, the likelihood here of that? And I always felt like even if jail time was warranted, that they're probably looking at more of a home confinement type issue because of the practical, even the judge said during the issues with the gag order that he did not want to put him in jail. He did not want to have to escalate this. But if he continued to act and violate the gag order, he would have no choice. And I think that's because of the practicality of putting a former president in jail. But he is someone who has violated the gag order. It's not like he's showing any contrition whatsoever, since sentencing. And aren't there steps that he has to do? He has to agree to have his life pretty much examined, his financial life examined by the probation office here over the next 5 weeks. And how much of that is voluntary and how much of that is mandatory?
He will be examined by the probation office, but it will not be that in depth. They're not going to start subpoenaing his records and getting into his books and things of that sort. It's more of a general overlook of this individual, his prior record, if he has any, and how he's conducted himself as an individual throughout his life. And we know he's bombastic and we know he can offend people, but he's never been arrested and convicted before of anything. So this is a first.
And it just happens to be the first case. He's got 3 other trials.
He's got 3 other trials.
But it is the first case. So, let's say a sentence comes in. And is there, before we get to that, is there anything that the defendant can do between now and July 11th to delay that sentencing? Can he, because, the whole thing on all of his cases have been appeal, get to the end of the campaign, do whatever you can to slow the works. Now that the conviction has come in, now that the judge has set the sentencing date, is there anything in this 5 weeks that he can do to delay this?
He only asked for an adjournment from the judge for whatever reason, and it's up to the judge. I doubt this judge would grant an adjournment unless something unexpected happens, but that's the only way this is going to get delayed.
So it's up to the judge.
Yep.
More than likely, and Judge Mershon is probably wants to be done with this.
Yep.
I would imagine. So, you know, I mean, it is 4 days before the Republican convention. You know, but all right, the sentence happens, and as you said, even if there is jail time, we're not looking at like him being carted off the Rikers at the end of the sentencing.
No.
There is avenues for him to appeal. So let's get into the timeline of that, and then we'll talk about where the possible appeals might come. But what is the timeline? You know, he's been convicted in the state of New York. You know, what are we looking at? You know, this case is not typical. There is no typical when it comes to Trump. But what is a typical defendant? What kind of timelines do we have? You know, to actually have an appeal of this case.
Right. So after the president is sentenced, the defense will file a notice of appeal. That starts the appellate process. He has a right to an appeal. Doesn't have to ask for permission to appeal. He has an appellate right. So he files that notice of appeal. That starts the process. Then the record on appeal needs to be compiled, and that's going to be voluminous, right? We need the transcript for the entire trial. We need all the documents that were filed on the case, and it needs to be put into a book, essentially, called the Record on Appeal, and that takes time. And then the side doing the appealing, in this instance, former President Trump, his team, they have to draft a brief, which is a lot of work, and file it with the appellate division, which is the next court above the court that heard this case. And once they file their brief, the prosecution has to file a response, and that too takes a long time. And then, of course, President Trump gets to file a reply. Now, typically, that takes about a year, more or less. But in this case, I would suspect that it's going to go much faster, and that the President Trump's team is going to perfect, as we say, perfect its appeal as quickly as possible and get this brief in front of the appellate division. So this one might be expedited not only by the efforts of the defense and its team, but they also might ask for expedited service by the appellate division. In other words, to hear it first, to put it at the front of the line.
Well, why would the defense do that? I mean, I know we kind of talked about this at the beginning before we got on camera here, but why would the defense look to expedite? Hasn't this, you know, Trump team in any case that he's had sought to just continue to delay? Is there any strategy? What would be the strategy of expediting it besides the fact that supposedly he thinks he's innocent and that he wants to have his day in court first? We all know that that's, you know, a little bit of a fantasy, but throw that out. What other reason would it be to expedite it?
Right. The reason there would be to expedite is simply this: if they think they're going to win on appeal. If they think they have like a 90% chance of winning on appeal, they're going to want to get that expedited so that they can vindicate the former president and trumpet that victory, right? If they think maybe if they have less than a 50% chance on winning on appeal, then they're probably going to drag it out a little bit, maybe even pass the election if they can. They're going to do all they can to slow roll it. Now, they've got a lot of different theories for their appeal. So one of them might have some legs to it, you know?
Well, let's talk about that. What do you think? What do you think of their chances of appeal? And can it, you know, and what is it going to do to the case in and of itself? I have my loose.
Okay, so there are several theories he can pursue on appeal. First, I think they're going to argue that the judge should have recused himself, that there was no way he could be fair and impartial. And the basis for that argument is that the judge had made a contribution to a Democratic candidate of, I think, $10. And the judge made a political contribution to a progressive organization in the amount of $15. And the judge's daughter works for the Democratic Party or Democrats in some fashion. I don't think that's a winner, but they're going to make that argument, and who knows? Another argument they have is a statute of limitations argument. And what do I mean by that? If the charge for falsifying business records was merely a misdemeanor charge, that has a 2-year statute of limitations. Former President Trump was charged more than 2 years after the alleged crime. The prosecution, you could say, circumvented that 2-year limitation by making it a felony charge, because they said he was doing it in furtherance of some underlying claim, which extended the statute of limitations.
Can I dial in on that a little bit?
Yep.
Because I think that that's an important thing. You know, one of the theories I heard about why they could not charge, obviously, is because he was a sitting president at the time that the crime happened, and there's a DOJ, guideline that you can't charge a sitting president with a criminal crime. So did that 2 years start before he was unelected in 2020 or after? And is that, and does that matter at this point?
I'll be honest in telling you, I don't know. And I would have to
We've never
examine
had
that.
this happen before.
Right. So
right.
that's new to me. I guess we could argue, or somebody might argue, if you're the prosecutor, that there's a tolling of the statute of limitations while he's still the president. I think they missed the statute no matter how you cut it, right? They didn't bring it within the 2 years, no matter how you cut it. But frankly, I think that's a loser, because he wasn't charged with a misdemeanor. He was charged with the felony, and felonies have longer statute of limitations, and they have them for a reason, because they're more serious crimes. It wasn't like the prosecution turned it into a felony simply to circumvent the statute of limitations. He charged it with
that's what they say, right?
That's what they say. That's what they say. But, there's no way they're going to convince an appellate division of that, because there is this felony charge. It's a legitimate charge under the law. It's recognized by the law. It's in our statutes. It's a second-degree falsifying business records charge. So the prosecution didn't make that up. That's on the books. First-degree falsifying business records is when you do it, you don't do it for some underlying crime, and that's a misdemeanor. Well, a second degree, it's a felony. It's on our books. It wasn't fabricated to circumvent the statute of limitations. It wasn't fabricated simply for this particular defendant. It's on our books. It is the law of New York State. So I think that argument that, it should have been the misdemeanor statute of limitations that applied and they blew it, is frankly a loser. So that's two. Venue. They're going to argue that they couldn't get a fair trial, which violates his Sixth Amendment right under the Constitution to a fair trial, because it was in New York and he didn't do very well when he ran for president in Manhattan, et cetera, et cetera. I think that's a loser.
I mean, if you don't like where the trial might be held, don't do the crime in that venue. That might be the remedy there. And I understand, if it was only a local case and the local publicity was so bad that you couldn't get a fair jury. But the theory is that not that you get a jury made up of equal number of Republicans and Democrats. It's a jury made up of the peers that, if you move this trial to, Oswego County, which is the most red county, it's not because there's still going to be people there who've heard of this trial, and just as many as in Manhattan. It's not
exactly,
that's why you move it. You don't move it because the people might be biased against you in their ideological beliefs. You move it because they've heard something about the case that can't make them unbiased, right?
And as you pointed out, like he lived in New York for his entire life until recently, and he did all his business in New York, and he had these meetings in New York, and the witnesses were from New York. It's a New York case. Those are his peers for all intents and purposes, as far as this case goes. So that's where it belonged. The next appellate issue that I see is the testimony of Stormy Daniels. And what do I mean by that? She provided a good deal of very detailed testimony that was completely gratuitous. And what I'm saying here is she talked about sexual details of the event she had with the former president. that shed no light whatsoever on what was being tried, and that is falsifying business records in furtherance of some underlying crime. I feel the judge should have shut that down. I feel the judge made a mistake in not shutting that down. I think it was wrong. I think it could affect the jury, and it could affect the jury improperly. All this stuff about what he was wearing and what she was wearing and what position they were in when they had sex and what his private parts look like and all that nonsense has nothing to do with what he was charged with. That was not good. Now, the appellate division will have to determine two things. Number one, was that an error not to shut down that testimony, or at the very least, give it an instruction to the jury? Ms. Daniels testified as to the following. That's not relevant to this. I'm going to ask that you disregard that testimony. Okay. So number one, did the judge make a mistake? And then number two, was that mistake so bad that it affected this jury to the point where it could not make a proper determination? And when the appellate division examines that, they're going to look at all the other evidence and see if there was so much overwhelming evidence of guilt that even with these gratuitous statements, he would have been found guilty anyway. So, but I think that one is, I haven't read the transcript. I haven't read the entire transcript. All right. But that one bothers me a little bit.
Isn't there something about that one? Yeah. I understand. The crime isn't whether he was good in bed. I mean, that's not the crime. It's essentially a crime that we had to hear about all of that. But but isn't part of, wasn't it, a duty of the defense counsel here to raise these objections and raise these issues while it was happening? I remember reading, and again, one of the problems with New York, and I understand the reasoning behind it, but not having cameras in the courtroom, those of us on the outside, we're dependent upon voices inside the courtroom to report it out. Eventually we'll get transcripts we can read, but they're not ready yet. They're not, and they're not really available to the general public. But isn't this incumbent upon the defense counsel to be raising these issues in the trial itself to create an appeal? And did they do that?
You're right that a defendant has to object. If you don't object, you waive it. There's no appellate issue. You waive it. It's my understanding that the defense team did object, and they objected a good number of times during this testimony, and the judge didn't shut it down. Now, I might be wrong because I haven't read the transcript, but that's my understanding. Now, if they objected and they made a record of their objections, and the judge ignored those objections or overruled them and allowed this testimony, in my mind, that's a mistake, right? That all that detail, gratuitous, it's prejudicial without any probative value. You hear a lot of lawyers say, object, that's prejudicial. Of course, anything the other side does is prejudicial. That's what you do. But the question is, does the prejudicial nature outweigh the probative value? The details of what they did in bed or in that hotel room has no probative value at all, but it has a good degree of prejudicial nature. So in my mind, it should not have been allowed in, but we'll see what the transcript says, and we'll see what the appellate division does with that. There are several other issues. I mean, Cohen's testimony. They're like, well, this guy's a proven liar. He's admitted to being a liar. His testimony should not have been considered. That's a loser. Okay. Almost every trial has somebody lying somewhere. Otherwise, we wouldn't have trials.
Not one mob boss would have been convicted that
right.
Without corroborating witnesses. Right.
Yeah. And a standard, what we call pattern jury instruction in New York State. This is a standard instruction to jurors, is what we call falsus in uno, which is a Latin phrase meaning, you lie once and it could be an issue. And this is what that charge says, boiled down to its simplest terms. Ladies and gentlemen of the jury, you heard from witness A, okay? There was evidence that witness A lied about some things. If you believe that witness A lied, you can reject all of witness A's testimony. You need not consider any of it if you deem him to be a liar. However, I am not telling you to reject witness A's testimony. You may still consider and weigh that testimony, even though you know he has lied on other occasions. You have to weigh his testimony and whether it has any value. So that's an entirely a jury call. And the jury believed Cohen. That's simple. What's another appellate issue? Oh, whether this verdict was unanimous or not, right? I've heard all the conservative talk radio stations say every defendant is entitled to a unanimous verdict for guilt, except for the former president. It was not unanimous.
But wasn't that not unanimous in the idea of the secondary charge, right? I mean, it was about they didn't have to be unanimous on what the crime was that escalated it from a misdemeanor to a felony, not the underlying crime itself. I mean, it wasn't the jury poll, it was a unanimous verdict for guilty or not guilty.
You're spot on. It was a unanimous verdict. It was 12-0 that he was guilty. Now, what the judge said is you have to be unanimous that he falsified business records, and you have to be unanimous that he did it in furtherance of some underlying crime. But you don't all have to agree on what that underlying crime was. It could have been crime A, crime B, or crime C. You don't have to be unanimous about that. And I think, I haven't researched it, but I think the judge is correct on that. They just have, and you know what? They could have been unanimous on that. That wasn't a question on the jury verdict form, right? They weren't even asked that. They could have been unanimous. You know what? It's very akin to conspiracy charges. If somebody is charged with a conspiracy, not only does the prosecution need to prove that there was an agreement between these people to do a bad thing, commit a crime, but it can't be just mere talk. In other words, they must have committed some overt act in furtherance of the crime to be a conspiracy, right? Well, the jury has to be unanimous that these people got together and decided that they were going to commit a crime together, but they don't have to be unanimous on what the overt act was, right? Juror A might think that, okay, the overt act was when he went and rented the car. Juror B might think the overt act was when they went and bought the gun, right? So they don't have to be unanimous on that. And I think that's going to be the case here too. I think that the prosecution is going to be fine on that issue on appeal.
So your opinion is really the only appeal with legs is the Stormy Daniels testimony right now.
That's the one that bothers me. Yep. That's the one that bothers me.
And again, just to recap, he's going to be sentenced July 11th. And we're looking at about a year and a half of appeals just to get through the New York appellate process, right?
Well, at least, right. Because number one, he's got to go. He's at Supreme Court now. That's a New York court, not the United States Supreme Court. The New York State Supreme Court, which is the court of first impression in New York. It's kind of backwards from the federal system. And then now he's going to, after he gets sentenced, he's going to go to the next court up, which is the appellate division. And if he doesn't like what the appellate division has to say, then he's going to go to New York State's highest court, which is the Court of Appeals, because he was convicted based on state law. And then the Court of Appeals is the end for those state law issues. However, the president may argue that some constitutional rights that he's entitled to were violated and try to get this in front of the United States Supreme Court, because only federal courts like the United States Supreme Court can hear issues regarding the Constitution and federal law. He may say, my Sixth Amendment rights were violated. I didn't have an impartial jury, or this was selective prosecution. Those are Sixth Amendment rights under the Constitution. And he may say to the Supreme Court, I need to hear, I need to be able to appeal to you now because the Court of Appeals has rejected me. And I don't know what the Supreme Court would do with that.
And again, that's after the year and a half, maybe 2 years of wrangling in New York court. All right, let's talk about two things here. What happens if he is elected in November? Can he stop this New York prosecution or the appeals process? He may be able to stop actually being put in jail. I know that there's a lot of legal theory on that. And of course, we've never had to deal with this before, which we have to say a million times over again. But does the appellate process go forward if he's elected president? Can the Court of Appeals go, but not the punishment? Or does it all stop if he's elected president in November?
It does not all stop. It's a state proceeding. The president has no power to pardon himself for state crimes. He has no control over state proceedings. People on perhaps the right like to talk about states' rights. Well, this is a states' rights issue. This is a state law, state court, and a state issue. So it will not stop. The appeal will go on. Now, if he loses all, let's assume for fun.
Yeah, lots of fun here.
Right. Because, I mean, there are so many different forks in the road on this thing, right? But let's assume that he's sentenced to some jail time and it's suspended. And the appellate process goes on and on and on. He ultimately lose. And let's say he's in the White House at that point. Will they then go take him and put him in jail? I doubt it. But I don't know the legal answer to that question, but I don't see that happening.
So then, since we're making all kinds of assumptions here, we assume he loses all of his appeals process. Let's assume he's not in the White House. And, his path then, the only path then is SCOTUS, and we don't know what's going to happen there. But our good friend, master of law, John Eastman, has come out today and said that the Trump team should do a writ of habeas corpus to SCOTUS today to circumvent all of this New York appeals process. Is that possible? Is it
Completely possible?
Yeah.
Completely possible. I'm glad you mentioned that because that's something I did want to mention. Yeah, they can go to the Supreme Court of the United States at any time and say, look, a constitutional right was violated. We want to get in front of the court. We want to have this heard today. So yes, that is completely possible.
And this Supreme Court, we just don't know what they're going to do.
I mean, look, you and I know in the normal course of things, the Supreme Court of the United States would never, ever, ever hear this case, ever, right? Whether it be immediately on a writ of habeas corpus or at the end of all his appeals, the Supreme Court of the United States would never hear this case. But this is a unique case. It is a former president. It is a candidate for president. And it is somebody that put a lot of these people on the Supreme Court. It's a very right-wing Supreme Court. So we are in unknown territory here. Anything could happen.
Of course, it is a right-wing Supreme Court that isn't notoriously known for being a defender of a criminal's rights here. I mean, this is not something that they normally would be akin to do if this was John Q. Public who's been charged with this crime. But
right.
So I guess we have a lot of waiting to do, and I'm sure we'll talk about this. And maybe we'll talk about this if there's another trial this year. There's still talk that if the Supreme Court comes back with the immunity argument, that there's possible that Jack Smith can get his case into September for the insurrection. It doesn't look like the Eileen Cannon, the Georgia case or the documents case is anywhere close to going to trial this year.
Right.
And we could spend a lot of time on Eileen Cannon if we wanted to, but we're not going to today. We're kind of getting towards the end of where, I like these podcasts to be, but so what haven't we talked about yet? What haven't we talked about with this case at this time that you would like people to know until the next time we talk?
Well, I just got to say, I want everybody to keep calm, right? Like this is a process, and it's a long, laborious, detailed process. That's how justice works. People on both sides of the political spectrum get so full of vitriol, and they all want an answer now, and they want drastic answers, right? Like on the left, people want to see Trump in an orange jumpsuit with handcuffs being marched off to prison. That's not going to happen. Take it down, relax. And people on the right, they want to see the judge be sanctioned and that sort of thing. That's not going to happen. All right. So everybody just needs to relax and let the process run its course.
Well, Steve, thank you so much for taking the time and coming on. I hope you'll come back and when we maybe after sentencing or, we'll see how things go. I mean, it's going to be a long, long marathon on this, but I'd love to have you back when we have some more, bigger news on this, and it
Yep.
probably looks like late in the year or early next year before we even know where this is going. But thank you so much. Thank you for always being there, and I hope you enjoy your week.
Perfect. Dustin, thanks so much, man. As always, a joy chatting with you.
And that was my interview with Steve Williams of Smith Sovak, former federal prosecutor and an area legal expert in both the federal and state of New York judicial process. So I was so glad that he was able to come on, kind of short notice, and talk about the Trump convictions that happened last week. This weekend, weekly wonk. I'll be starting my look at the assembly districts in Onondaga County. Assembly District 126 is the only Republican held district, and I'll be starting off with that starting this next week. Next week's Commissioner in the Car will be about the start of early voting for the June primary. So check that out on Tuesday. And Zoom with Czarny next week will be Stacey Finney, mayor of Liverpool, talking about the upcoming village elections and the proposition to move village elections to November that's happening in Liverpool, that's happened in 7 other villages in Onondaga County. So check it out. Always go to dustinczarny.com. You can subscribe and also get an email notification anytime I have content or election news updates. I always pay for that out of my own money, no ads, no subscription fees. I run it all myself. I take no outside money for it. It's part of my public education projects for Onondaga County in my role as elections commissioner. So I hope you enjoy. Bye-bye.